3 words just detonated the illusion of control. You were untruthful. And suddenly, the courtroom air around Prince Harry felt less like justice and more like a slow-motion collapse everyone could see coming, but no one could stop. Because this wasn't some random witness fumbling dates. This was the star researcher, the credibility guy, the man brought in to give weight, seriousness, authority. And now he was being accused, in open court, of saying one thing under oath while paper evidence screamed the opposite. The kind of contradiction that doesn't just bruise a case, it rips the floor out from under it. Dr. Evan Harris was supposed to be the steady hand, former MP, connected to Hacked Off, a familiar face in campaigns against tabloid misconduct. His presence was meant to tell the judge, this case is serious, this evidence is solid, this isn't celebrity whining. Instead, his testimony may have become the defense's favorite gift. Because when Anthony White, Casey for the defense, calmly suggested Harris had been caught out, the temperature in the room reportedly changed. Not loud, not theatrical, just that quiet electric shift when everyone realizes something important just broke. Harris had said Operation Bluebird, a key investigation memo tied to alleged wrongdoing, was new to him. He'd never worked on it, never been involved. Clean, simple denial. Then came the grenade. Emails and drafts showed he hadn't just seen the memo, he had edited it, rewritten sections, made substantive changes, not a passing glance, hands-on involvement. And suddenly, the question wasn't about Bluebird anymore. It was about honesty. You could almost feel the defense leaning back at that moment. Because when a central witness looks shaky, everything they touch starts to wobble. Every conclusion, every summary, every confident statement now carries an invisible asterisk. And the irony? Brutal. This entire legal crusade is built on the idea that the press twisted truth, that powerful media figures crossed lines, that Harry was fighting for accountability. Yet now, in the very arena where truth is supposed to be pinned down with precision, his own side is battling credibility questions, not proven lies, not convictions, but doubt, and doubt is poison in a courtroom. This isn't a tiny lawsuit either. This is a massive, years-long legal war involving Associated Newspapers, the company behind the Daily Mail. Harry and other claimants reportedly poured tens of millions into this fight. The stakes aren't emotional, they're financial, reputational, existential. Because if your expert looks unreliable, the defense doesn't just poke that one hole. They start asking, what else is wrong? What else was misremembered? What other documents passed through those same hands? And Harris's explanation? That he simply forgot. Forgot being sent the memo, forgot editing it, forgot engaging deeply enough to rewrite portions of a document central to a multi-million-pound legal case. That's not a small memory lapse. That's the kind of claim that makes a judge lean forward very slowly. This was also not day one nerves. He had been on the stand multiple days. Multiple chances to clarify, multiple opportunities to correct himself before the defense dropped the paperwork. The longer an omission lasts, the harder it is to sell as innocent, and this isn't happening in isolation. Earlier in proceedings, another supporting witness reportedly backed away from previous statements, raising fresh questions about reliability. One shaky witness can be managed. A pattern? That's narrative. The defense doesn't need to prove some grand conspiracy. They just need to make the court wonder whether the foundation is solid. Because once a judge starts asking, can I rely on this? The uphill climb becomes vertical. Hovering over all this is another legal landmine: timing. Statute of limitations, dry phrase, deadly consequences. If certain claimants reasonably could have known about their potential claims years ago, the entire case, all that money, all those witnesses, could be ruled too late. Game over without even reaching the juiciest allegations. And guess who had testimony tied into that timing argument? Harris. Which means credibility trouble in one corner spills directly into another. Now step back from the paperwork and look at the bigger picture. Harry didn't have to push this all the way. Settlements exist. Quiet exits exist. Face-saving compromises happen every day in high-profile disputes. But this fight feels personal, like a mission. Like backing down would feel like betraying his own story about who hurt him and why. And that makes every courtroom setback heavier. Because it's not just legal strategy cracking, it's identity. Meanwhile, the financial exposure looms. Legal battles at this level don't just nibble at wealth, they chew. And if things go badly, the bill doesn't stop at your own lawyers. Behind palace walls, you can imagine the complicated mix of emotion. Concern, frustration, Maybe even a quiet, unspoken "we warned you." Public wars have private costs, and this one is playing out in transcripts and cross-examinations instead of headlines and interviews. The saddest twist? The man who once charmed crowds with easy humor is now defined by lawsuits, depositions, and legal brinkmanship. Courtrooms instead of causes, litigation instead of reconciliation, and now his case hangs, at least in part, on whether a key witness simply forgot rewriting a crucial document, or whether that explanation convinces absolutely no one. Because in court, perception is power. And right now, perception is shifting. And just when it seemed like the damage was contained to one disastrous moment on the stand, the ripple effects started spreading through the rest of the case like cracks racing across thin ice. Because courtrooms don't isolate embarrassment, they amplify it. Once credibility wobbles, every prior statement gets dragged back under the microscope. Every confident conclusion now has defense lawyers circling it with invisible red ink. The strategy becomes brutally simple. If the court can't fully trust the messenger, why should it trust the message? That's where things turn from uncomfortable to dangerous. Because the legal fight was always about more than a few disputed articles. It was meant to establish a pattern, a culture, a system of alleged wrongdoing. Big claims require sturdy evidence. And sturdy evidence requires witnesses who look solid under pressure. Not witnesses scrambling to explain why sworn testimony doesn't line up neatly with documented edits. And hovering behind all of this is the ticking clock argument, the one that could quietly suffocate the entire case without ever reaching the emotional heart of it. If the court accepts that some claimants should reasonably have known enough, early enough, then the whole legal crusade risks being labeled simply too late. No dramatic verdict, no sweeping condemnation, just procedural finality. Imagine pouring years, energy, reputation, and staggering legal costs into a battle, only to be told the door was closed before you even knocked. That's the shadow now stretching across the courtroom floor. What makes this even more intense is that this lawsuit was never just a legal maneuver. It was part of a personal narrative, a larger story about betrayal, exposure, and fighting back. Walking away would have looked like surrender. Settling might have felt like silence, so the gamble continued. But gambles are only heroic when they pay off. When they don't, they look reckless. Outside the courtroom, the pressure multiplies. Deals that once promised financial freedom haven't all delivered the long-term security people assumed. The glossy image of post-royal independence runs into the hard math of legal warfare. Court cases at this level don't politely stay within budget. They expand. They consume time, focus, and cash in equal measure. Meanwhile, relationships that were already fragile grow more strained. Public conflict has a way of freezing private healing. Every new legal headline is another reminder of distance, another reason for conversations not happening. While King Charles III faces serious health challenges and Prince William carries increasing royal responsibility, the gulf doesn't just feel emotional, it feels permanent. And yet the lawsuits keep coming, like momentum is taken over. Some observers quietly wonder whether the courtroom has become the one place where control feels possible, where grievances get structure, timelines, rulings. Real life is messy and unresolved. Legal battles offer the illusion of clean endings. But courts are designed to decide legal thresholds, not emotional truths. They don't rule on who felt most hurt. They rule on evidence, timing, and credibility. Cold categories, hard edges. Back in California, the brand built around reinvention has also had its share of turbulence. The big entertainment partnerships that once looked like golden bridges into a new era didn't all turn into lasting empires. Spotify ended with sharp public commentary. Netflix delivered attention, yes, but attention isn't the same as enduring influence. Even charitable work, the one area that once felt untouchable, now gets viewed through a more skeptical lens. Projects launch with fanfare quietly changing hands. Initiatives announced loudly then fading from headlines. The exception, of course, remains the Invictus Games, still widely respected, still deeply meaningful to the veterans it serves. But even there, whispers surface about how complicated royal associations have become when legal wars with British institutions are ongoing. Then there's Meghan Markle, whose public image remains inseparable from all of this. Fairly or not, every courtroom twist splashes back onto both of them. The narrative isn't his case. It's their saga. Supporters see bravery, critics see obsession, neutrals just see endless conflict. And conflict fatigue is real. Audiences that once leaned forward now sometimes lean back, not because they've chosen sides, but because the story feels stuck on repeat. Accusation, pushback, fallout, explanation, new accusation. Which brings everything back to that single explosive moment in court. A witness, a document, a contradiction. 3 words suggesting untruthfulness. It wasn't just a legal hiccup, it was symbolic. Because this whole battle was framed as a fight for truth. And now truth itself feels blurred, contested, fragile on every side. Can the case still survive? Legally, yes. Trials are long. Evidence is complex. Judges weigh nuance, not internet commentary. A single witness issue doesn't automatically doom an entire claim, but it makes the road steeper, the margin for error thinner, the defense bolder, and reputationally, damage doesn't wait for verdicts. It seeps out during the process. Each shaky moment becomes part of the public memory. The harshest twist is that none of this brings peace. Winning wouldn't restore lost years. Losing wouldn't erase past pain. The courtroom can assign costs some responsibility, but it can't rewind history or rebuild trust. So now the spectacle continues. Part legal drama, part personal reckoning, part cautionary tale about what happens when private hurt and public warfare collide. A prince who wanted accountability now faces questions about the accountability of his own side. A man who said he was done with royal life remains entangled with it in every headline. And somewhere behind the legal filings and dramatic cross-examinations is a simpler, quieter truth. Every battle you choose shapes the life you end up living. Right now, that life looks less like freedom and more like a never-ending day in court.